As I said before, I like to answer questions, and some people don't believe the answer is simple as I give until I give it. Okay, this is an extensive question. Uh, Actually, it's multiple questions. What is a subject matter jurisdiction? Subject matter jurisdiction refers to court's legal authority to hear and decide a case based on the nature and dispute, the power granted to the court by constitution or statute to adjudicate cases of a particular category or type. This jurisdiction does not depend on the parties involved, but solely on the type of case being presented, whether it's criminal, civil, probate, family law, federal constitutional law, etc. And I told you my answer, you can throw in, no matter what court you're in. It's a simplistic answer. You can, no matter what court you're in, all these courts, civil, probate, family law, federal, it's because the rules of professional conduct and the code of judicial conduct are the common denominator in every court of law. Okay, these are legal obligations of all lawyers and judges, no matter what court of law you're in. Okay, and that doesn't happen. Nobody does that. So that's the simple answer. Okay, what subject matter jurisdiction is important, non-waivable, and non-conferable? It cannot be waived by parties or conferred by consent. Now remember, before you can give consent, the proper term is informed consent. Okay, so before you can give consent, you have to have reasonable knowledge to make an informed decision to give informed consent. And everything I've been posting about is reasonable knowledge. And so you didn't know any of that. And you didn't know the rules and the codes, and they existed, and these are legal obligations of all lawyers and judges. And you didn't know effective assistance of counsel guaranteed in the Sixth Amendment is not structured just for your attorney, but it's a double-edged sword. It's meant not just for your attorney, but for the court itself, because the rule of professional conduct and the code of judicial conduct is what establishes effective assistance of counsel. So if you can prove ineffective assistance of counsel, you can prove the ineffectiveness of the court, because it's the legal obligations of all lawyers and judges to report misconduct, any violation of the rules or the codes as misconduct. And since nobody abides by the rules and the codes of conduct, or the rules or the codes, everybody's legal to report each other and themselves as well, and as violating the oath, and the oath requires them to see to it that you have effective assistance of counsel. So it's easy to prove not just ineffective assistance of counsel, but ineffectiveness of the court, which is denying you to process a fair trial. So it's utterly ridiculous, and I've always found it fun when I talk to lawyers and judges using the rules and the codes. I always leave them dumbfounded. I'm going to do a video after this going through the rules and the codes with you, and how a lot of people think it's a casual conversation, but it's actually legal talk. Void judgments. Any judgment issued by a court without subject matter jurisdiction is void, not just. So all he's explaining here is a lot of legal harassment, because they didn't do what they were supposed to do in the very beginning, and he's fighting them on it. See, a lot of this is illogical to him, and right now they are requiring them to have the legal knowledge of a learned professional, a learned seasoned professional. Somebody with the legal aptitude of that of a graduate from law school. How is that fair? It's not. And it's because he had ineffective assistance of counsel. He just doesn't know exactly yet what I'm getting at. Or whoever this person. Diversity of citizenship, civil cases where parties are from different states and amount in controversy exceeds 75,000. Okay, state courts handle most criminal prosecutions, family law, divorce, custody, property disputes. Louisiana courts, civil and criminal, People in some states they removed. Sorry. Some states they removed some of the rules, which is illegal. So you'll want to refer to the American Bar Association model rules of professional conduct, as well as the model rules or the Code of Judicial Conduct on the ABA. They can't. No. They I nearly had a heart attack when I was looking through every state and found that they move a very important one, Rule 3.8, special responsibilities of a prosecutor, and that's in the interest of the bar and not in the public interest, which it will tell you in the preamble. They must do what's in the public interest, not program interest or interest of the bar or self-interest. Okay, city parish courts, limitations to misdemeanors. Okay, juvenile courts, and juvenile courts, kids aren't given due process. I mean, it's hard to say where they hit you hardest in the court, but nobody plays by the rules or the codes. So when you got a kid that's in juvenile court, you make sure. Listen, I understood the Constitution when I was 10 years old and knew that wasn't happening. That was in 71. Kids are a lot smarter now than they were in 71. Sit down and read it with them. Remind them, these are your birthrights. These aren't just your constitutional rights. These aren't just the Bill of Rights, etc., etc. But these are your birthrights. These are your your constitutional rights are their constitutional duties. The constitutional duties of every public servant. A legal binding contract that they cannot violate. Violating the oath is mandatory fines, removal from public service, and incarceration, and in case of death, the death penalty. Okay, jurisdiction over subject matter. So he's talking about a lot of stuff that, challenging subject matter, Louisiana Code of Criminal Procedure, all post-conviction relief where the court lacked jurisdiction. Yeah, they like to play with you when you file a post-conviction. I filed for a lot of people, but they didn't understand how important it was for them to put their name on it, not mine. It seems like what my name is on is just disappears. But I did file for this one guy. Well, I had him put his name. I wrote him up late notice of appeal back in 91 in Centralia Prison. His lawyer didn't file for the appeal, kept his money, $7,500. He called the lawyer. His wife tried talking to the lawyer, and he was just, well, sue me. That was it. He just, he had no intention of filing an appeal. A lot of lawyers do that. They'll say, okay, you'll be in trial. Let's say, hey, we'll come back on him an appeal, and that always tells you right now you lost already. So I just sit there, run. No, I'm not. I'm kidding. Don't run. But so the lawyer didn't file the appeal. He was complaining about it. I told him just file a late notice of appeal. He said, what's that? I said, well, when your lawyer doesn't file an appeal, you can file a late notice of appeal. I think at the time it was a 90-day statute of limitations on it. And he only had like maybe a couple weeks left. So I used what I used to call the ineffective assistance of counsel defense, which is today is known as a conspiracy against rights under the color of law. And I noted the deprivation of rights, and I cited all the violations in the rules and the code, cited the judge for judicial misconduct, the prosecutor for prosecutorial misconduct, the attorney for ineffective assistance of counsel. I mentioned how the attorney violated every rule, and he wouldn't have or couldn't have if the judge and the state's attorney had reported that attorney for ineffective assistance of counsel. So they were actually giving an aid and assist to deprivation of rights, your deprivation of effective assistance of counsel. And in the ending, I threw in couple lines, from the preamble and the public interest, maintain the public trust, expedite this litigation, which is a rule of professional conduct. It would be diligent, which is in the rule of professional conduct. It would be competent, which is a rule of professional conduct. Did I communicate myself correctly? Communication is a rule of professional conduct, and the rules are laws themselves. Okay, and he was out like about 2 weeks later. 2 weeks later. I told him, just go to the library, have them notarize it. Don't sign it. Have them notarize it there. I said, make several copies. I said, I would make 10. And make sure people hang on to them for you, besides keeping one for yourself. I said, you're going to have to supply one to the court and send them copies so that way you can forward one to the state's attorney. You can do that yourself. And I explained to him that you can sue because, and when you sue, you can ask for a declaratory judge, or not a what's it called? Summary judgment, because there's no defense. There's no defense for when you cite somebody for ineffective assistance of counsel. You're saying they willingly and knowingly violated the rules of professional conduct to put you in the position that you're in, and they got the aid and assist from the court, the opposing party, and the judge. So that's easily a conspiracy against rights under the color of law. Okay, nullify conviction. This is how you nullify a conviction, even if it was a murder. If a murder or conviction was rendered by a court that has no statutory or constitutional authority to try murder cases, is it automatically void? Yes. Okay, so there's a lot of questions. Subject matter, jurisdiction, threshold, legal. Okay, so let's go to my answer. Much to discuss, obviously, but when you start from the beginning, because if all this didn't happen in the beginning, much to discuss, obviously, but we must start at the beginning. From the very start of for the very first appearance, there are many mandatories unfulfilled, and that is the key. From the very start, the legal term of conspiracy against rights under the color of law, and realizing that is what you're defending yourself against. First step, look up the rules of professional conduct, the code of judicial conduct. Nobody did that, so you have a lot of ammo. There's a whole lot of misconduct, and reporting misconduct is mandatory, both the rules of professional conduct and the code of judicial conduct. Everybody is legally obligated to report each other as well as themselves. Violation of the rules and the codes is called ineffective assistance of counsel. Stating everything your lawyer didn't do is citing ineffective assistance of counsel. That's the opposing party and the judge's legal obligations to do, and not doing so shows the ineffectiveness of the court and the legal system in its entirety. You could literally walk into court and say, Your Honor, do your job and cite my attorney for ineffective assistance of counsel for violating the rules of professional conduct, and the opposing party for failing to report my lawyer, and yourself for not reporting the said violations. Your failure to report thus far puts you in contempt of the very court you preside over. Your failure to report now, as well as the attorneys involved, would further that charge of contempt, but furtherance of this conspiracy against rights under the color of law. That's a federal offense and has penalties that require fines, removal of public service, and incarceration. Now let's everybody do their job, live up to the oath you took, stop the deprivation of rights, print out the rules of professional conduct, code of judicial conduct form. Okay. So I should have ended it there. So I'm telling you, in this part, print out the rules of professional conduct, the rules of professional conduct complaint form, the code of judicial conduct complaint form. Also, Google conspiracy against rights under color of law, the conspiracy against rights under the law complaint form, deprivation of rights under color of law, deprivation of rights under the law complaint form. Look up penalties for violating the oath and work with that. Also, what they didn't do is unethical, so file ethics complaints on everyone. And well, tell them this is their job description. What you've been through since is nothing more than legal harassment, strictly forbidden in the rules of professional conduct, which is law. They were doing it to get you to give up, walk away, file a writ of habeas corpus based on a conspiracy against rights under the law, and you have an automatic win. Clarence Thomas just gave a decision stating that qualified immunity can't, qualified immunity can't exist if a conspiracy against rights under the color of law is proven. Okay, so qualified immunity cannot exist if a conspiracy against rights is proven. Easy peasy. Nobody played by the rules and the codes. And the hard part is, just reading the rules and the codes. I mean, come on, print them out. I tell people all the time, print them out and highlight everything that didn't happen in your court. Listen, not all the rules apply in every court, but the rules apply in every court. So in every court you're in, you look in there and you're going to find stuff that applied to the court that you were in, and that didn't happen. Okay, so I'm going to go over with the rules and the codes with you, but no matter what court of law you're in, you use the rules and the codes against them, their job description, their legal obligations. They don't do it. So that's a whole lot of ammunition, and they work together. So that's conspiracy. They denied you your constitutional right, effective assistance of counsel. And like I said, once you prove ineffective assistance of counsel, you prove the ineffectiveness of the court. The ineffective assistance of counsel is quite literally a double-edged sword. Okay, so I'm teaching you to stop the conspiracy against rights. And no matter where you go, if you read the Constitution, that's not happening. And now there's this constitutional crisis, and the only constitutional crisis was where one branch of the government is exceeding their authority and ignoring the other branches and just doing what the hell they want. And that's illegal. That's usurping the Constitution. I did a video on that, usurping the Constitution and what you can do about that. People, all my videos are showing you what you can do about it. I'm just one man, one person here. All right? And I'm giving you the answers. And it's pretty, I didn't even go through the whole thing. I'm going to do another video of an extensive answer that you can say to the judge. And it's just, do your job. Do your job. But you're going to need the rules and the codes with you. They don't allow electronic devices, so you have to print them out and highlight every issue that didn't happen. Okay, I understand you're afraid because it's a law, but if you understand anything I just read, you're going to understand the law. It's just that when you have somebody in the legal profession that tries to interpret that law for you, it's usually devoid. In every sense of the word, it is devoid of the letter of the law. So incite the letter of the law, meaning they have to do what is written word for word. And letter of the law is a pretty simple law. They have to do what is written word for word to the letter. And that's so we hear, say, and see the same thing. That's the interpretation I use. The law itself. I just read it. Everybody hears the same thing. Everybody sees the same thing when I read it. And everybody thinks the same thing when they read it. So it's letter of law is beautiful. Use it, use it, use it. And especially when it comes to the Constitution, the rules, anything written, actually, in a court of law, in a court, in any laws, And remember, they must be in the public interest, All laws written must be in the public interest. Anything other is null and void. Okay? And if it's illogical, it's illegal. Okay, I gave you a simple answer to a multitude of questions. Okay? I hope I made that easy for you, And, to be honest with you, I've seen a lot of my other posts as well. But I'm going to give you an extensive one in the next video. I won't be reading a lot. I'll just shoot from the hip. And hopefully somebody will type it out and give it to everybody. And so for everybody, if you got a case going right now, I'm going to teach you what to say. And every time I've had somebody do it before, I bring up the rules and the codes and the penalties and the violations, and the case got thrown out. But you know what? The law requires removal from public service and incarceration, and That's not happening. So that's what I'm pushing for, all right? If you want to take down a crooked judge or a crooked lawyer, use the rules in the professional conduct and the code of judicial conduct, and that'll make it real easy for you, okay? And then Google the rules of professional conduct complaint form, the code of judicial conduct complaint form. I'm not doing it as a deprivation of rights, so type in the deprivation of rights complaint form, conspiracy against rights complaint form, violating the oath, penalties for that, and then look up for a complaint form. There's so many things you can do. Okay, so right now, I'll be honest with you, I feel alone because all these videos, all these posts I make trying to teach people what they do, all they make are comments. I'm not looking for followers. I'm looking for leaders, people to lead the way. I'm old. I need somebody to continue with what I've been doing for so many years, and I don't care how old or how young you are. The younger you are, the better. The quicker it is to absorb this, remember this. I'm going over your birthrights. You're talking to you about saving your trust fund, okay? This isn't about me, and this isn't just about you. It's about us, all of us. It's about we the people. It's about when you take a pledge of allegiance and who you pledge allegiance to. My people, your people, our people, we the people. The red, white, and blue doesn't stand for defending your government. When you took a pledge of allegiance to the flag, you didn't take a pledge of allegiance to a government. I didn't. Did you take a pledge of allegiance to a political party or a politician? No, when they took the oath to you, to serve and protect you. Why are you putting them on a pedestal? Time to kick the pedestal from beneath them. Use the law. That's what legal reform is all about. Getting you to stand up for yourself. All right? Getting you to get in there and demand your constitutional rights. As a United States citizen, your birthrights. And all you got to use is what they put on paper. If they can't be true to what they put on paper, use the law, that paper, to put them away. The law requires it. I mean, how many public servants out there compared to the millions and millions? I forgot what the count was on We the People. Pushing 400 million, I don't know, but come on, people. I'm just encouraging you and showing you where. Instead of complaining to me, instead of complaining on the internet, do something. And I'm showing you where. And you can do it electronically. You can do it electronically. I mean, once you put your words to paper and you put it in a court, we can change the two-tier justice system. We can kill it. We can see it. There's justice for all, and that all laws matter. I mean, since the Constitution was written, where it said, a nation where it said that all are created equal and endowed by their Creator with certain inalienable rights, and amongst these are life, liberty, and the pursuit of happiness. And as a Chicano, a Mexicano, a Mexican American,